Hi guys, welcome back to my channel. This is Battle with Ola. My name is Mujela Olua. Today I want to talk about Rylands and Fletcher, the principle in Rylands and Fletcher, and I'm bringing up this decided case because as you know, I'm a mediator. So in the course of last week, I mediated a session that had to do with two neighbors that were at loggerheads because of certain fixtures and fittings in each person's property that was overlapping and intruding into the other person's property, much to their displeasure. So I brought up this rule and I explained to them the principle in Rylands and Fletcher, and that's why I thought to do a video on it today. So let's talk about Rylands and Fletcher. It's an 1868 case. It's an old case, and it's one of those locus classicus cases. Locus classicus means that that's the case that in which the principle of law was established. Like when I talked about Donoghue and Stevenson, which established the case of negligence. So this case also established a rule of law, which in the simplest form just means that he who keeps on his property is something that is liable or capable of escaping to his neighbor's property and causing damage, keeps it at his own peril. That is, he is bound to keep it such that it does not actually escape into his neighbor's property to cause damage or mischief. And if or in the event that it actually escapes and causes damage or mischief, he will be liable. He can be sued for such damage or mischief and will be liable to pay damages now, to his neighbor when found guilty by the court. So that's the principle that was established in Rylands and Fletcher. If, for instance, you as a person, you are rearing monkeys and your neighbor is cultivating a banana plantation, you keep those monkeys at your own peril because they are capable of escaping and causing mischief to your neighbor's banana plantation and in effect your neighbor. So you keep those monkeys at your peril. That is, you must take all necessary care to ensure that those monkeys do not actually escape onto your neighbor's properties to cause damage. And in the event that they escape, your neighbor can sue you and you will be liable, in tort. That's the principle in Rylands and Fletcher. So here's what happened in the case. Mr. Fletcher wanted to construct a fishing pond on his land. He wanted to construct a fishing pond or a water reservoir, as some law reports have reported it. So he employed contractors who were experts in their field, and they started constructing, and they found unused or disused mines in the land, but they assured him that it was nothing. Those mines shafts were filled with earth or sand, and so they posed no danger. So they constructed it and filled the reservoir, the pond, with water. Meanwhile, his neighbor, Mr. Rylands, had a coal mine on the adjacent land, and after they filled the pond with water, the water escaped and flooded the coal mine. So Mr. Rylands sued. He sued for the flooding of his coal mine due to the activity of his neighbor, Mr. Fletcher. The trial court held in favor of Mr. Rylands. Mr. Fletcher appealed, and the court again upheld the decision of the trial court, and he further appealed. The appellate court also held in favor of Mr. Rylands. So essentially, all of them held him bound to have taken care to ensure that his water did not flow into his neighbor's coal mine to destroy the coal mine. So he was held liable and responsible for the destruction of his neighbor's coal mine by the water from his pond. So the court will look at some key factors before deciding for a plaintiff or a claimant in this kind of tort or in this kind of lawsuit. The first is that the court will look at the thing that was brought upon the land. So the first point is that was something brought upon the land. Land exists on its own. Okay, if grasses are growing, they are growing out of the land naturally. But when you now bring something on the land, you have brought something. So the court will look at it. Did you bring something on the land? In this case, Mr. Fletcher brought a construction project on the land. That is, he tried to construct a pond on the land. So he brought something on the land. That's one. Then the court will look at two. The use of the land. Is it a natural or a non-natural use of the land? in constructing the pond on the land, it was a non-natural use because ponds or reservoirs do not naturally exist on that particular plot of land. So for instance, if you have come to construct a house on your own piece of land, which is now interfering with your neighbor's enjoyment of his own property adjacent to yours or near yours, you will also be held liable because that's a non-natural use of the land. I've said that the court will look at, one, did the defendant bring something on his land? Two, in bringing that thing on his land, was that a non-natural or a natural use of the land? Then the third thing that the court will look at is the thing brought on the land. Is this something capable of escaping and causing mischief? The court will look at it. In this case, you know that water was brought on the land into the water reservoir. So it was capable of escaping and causing mischief on the adjoining coal mine. Yeah. And the fourth thing is that did the thing actually escape and cause damage or mischief? So if you look at the case of Rylands and Fletcher, you see that all these four criteria for deciding if the Fletcher was liable were fulfilled. Yes, he brought a pond onto the land. It was a non-natural use. It was capable, water was capable of escaping and causing damage to his neighbor's property, and it actually escaped and caused the damage. So the court held in Mr. Ryland's favor. This is a case of strict liability. It's a case that actually established the tort of strict liability, which means that the court will not even look at were you negligent, but essentially these four criteria have been fulfilled, even if you as a defendant were not negligent. So the court is not really trying to look at if you were negligent or not. So you not being negligent will not absolve you of the blame and the liability caused by your acts, as in those other four criteria. So then another consideration that the court has added along the line is foreseeability. The damage that was caused, was it foreseeable? If it's foreseeable, the court will hold in your neighbor's favor, that is in the claimant's favor. A claimant can get redress in terms of damages for the physical harm caused to his property. So that's the remedy available to the claimant. Now, there are some exceptions to the rule in Rylands and Fletcher. Essentially, if you get what I'm trying to explain, just use the monkey and banana example. So if you are rearing monkeys and your neighbor is keeping a banana plantation, you have to be very careful such that the monkey does not escape to destroy your neighbor's banana plantation. So you can liken it to several other incidences. For instance, if you have a dog and you're rearing a dog, you have to ensure that it does not escape onto your neighbor's property, maybe to bite your neighbor's children or to cause some destruction that you would now be liable for. So this law and this case seeks to preserve good neighborliness. That is, even though you have absolute right over your own property as to enjoyment and what have you, you have to consider your neighbors. So you make sure that your own right does not affect their own right, okay, so that everyone is happy at the end of the day. And where someone infringes on the other person's rights to use their property and enjoy their property, there will be remedy. Ubi jus ubi remedium. Where there's an injury, there must be a remedy in law. So, but there are some exceptions, like I said, and there are one, consent. If it's something that you consented to, you cannot sue. So they say that you cannot enter into the water and start claiming that you're feeling cold. Yeah, that's a Yoruba proverb that I translated or transliterated. But what it means is that if, for instance, your neighbor took or sought your permission to construct what he constructed and it's now affecting you, you cannot turn around and then sue your neighbor, because you have consented to the construction, you have consented to the use of the land, so you cannot turn around and sue. That's consent. The second one is common benefit. If, for instance, in the case of the water reservoir, you and your neighbor agreed to construct the water reservoir, and now it's now affecting your own land, even though it's affecting you, you cannot turn around and sue, because there's a common benefit to be derived from what is now causing you harm. So you look for other ways to resolve it, but you cannot sue your neighbor. Your neighbor will not be liable for what you are going to commonly benefit from. So, for instance, there's a generator in your estate. All of you have agreed that it's going to be supplying you power. But it happens that this generator is also supplying noise. You cannot just rise up and sue, because who are you going to sue? The people that you are commonly enjoying the benefit together? No, you have to find other means of resolving it. So where there's consent, you cannot sue. Where there's common benefit, you cannot sue. If you sue, the court will remind you of this, because the other party will bring it up and you would not get any reparations or any results. Another exception is the act of a stranger. So if, for instance, it's a stranger that has caused the act that has now resulted in damage on your property, your neighbor will not be responsible. In the case of the dog instance that I gave, if, for instance, your neighbor is known to have always tied his dog and taking proper care of his dog such that it doesn't escape into your own house to bite your children or other of your proxies and privacy, and maybe a stranger comes into your neighbor's house and maybe without your neighbor's knowledge or permission sets the dog loose, and the dog now prowls around and ends up causing injury or harm to your own children or privacy or proxies, you cannot sue your neighbor, or even to your property. You cannot sue your neighbor because that's not on them, it's on the stranger, and they did not know or approve the act of the stranger. So that's another exception. Another exception to the rule is contributory negligence. That's the default of the claimant. So if there's a default by you, the claimant, resulting in the injury caused to you by your neighbor's act, you would also be liable or guilty of contributory negligence. So you might go to court, but you come back with part of the blame. So contributory negligence, very important. That's the default of the claimant. That's one other exception to the rule in Rylands and Fletcher. Another exception is statutory authority. If, for instance, it's a government body or a public body that has come to construct the reservoir in that case, and they are constructing under lawful authority, you cannot just turn around and sue them for what has happened. Okay, if for instance the government is constructing road in front of your house and the road is now obstructing your passage for some time, you cannot sue the government because that's a statutory body, or maybe that's probably the road construction agency of the government and they are doing the road based on law. So you cannot sue them for the obstruction they are causing to your ingress and egress from your own property. So that's another instance of an exception to the rule. And the last exception is an act of God. So if, for instance, the flooding that happened in Mr. Ryland's property, if it was an act of God, maybe a natural flood, maybe there was excessive rainfall and it flooded water into the coal mines, he could not have sued because it is not an act of man, it is an act of God. So essentially, this rule of law is trying to establish one thing. You have a property, your neighbor has a property. Both of you have a right to enjoy it as much as you want to. But when your own enjoyment begins to affect your neighbor adversely, whether you are acting out of negligence or not, you are strictly liable for such damages or injury caused to your neighbor. And if sued, you will be held to pay damages to your neighbor. So we all have to be very careful the way we use our property. And like I've said, the exceptions abound. In those cases, you have to look for other means of getting redress of maybe coming to terms with your neighbor, or making sure that such damage is stemmed or nipped in the bud. But you cannot just sue in those instances. And of course, I've told you what the law will look at before arriving at the fact that, your neighbor is liable. So I encourage you to read up more on this law. It's a very important principle of law, and you can even use it in your daily interactions with people, interpret it into even wider, give you wider coverage, even if it's not an actionable coverage, but you can use it in other aspects. For instance, you're making noise in your own house, you're disturbing your next door neighbor. He might not sue you, but remember the rule in Rylands and Fletcher and lower your noise, because you're already interfering with your neighbor's enjoyment of his property. So that's all I have for you in this video. I will see you in my next video. Please don't forget to subscribe, like, and leave me comments in the comment section. And you can always mail me at houseoflivingstones@gmail.com. I will see you in my very next video. Toodles.